Good afternoon. Thank you so much for joining us. Don Barthel and Greg Fletcher are leading today's case law update. We're going to do some introductions, and I think Greg is going to start us off.
Hello, my name is Greg Fletcher, and I've been with Bradford Barthel for about 26 years, so that's quite a bit of time. I practiced workers' compensation most of my career, workers' comp defense. I practiced in Southern California and Northern California, so I kind of know both versions. And yeah, I'm in the Sacramento office, and if anybody needs anything, give me an email or give me a call.
All right, let's do some cases. And by the way, we will not get through all this case law. There is a ton of it, but I believe that all the cases, especially at the end, are self-explanatory. All right, the Cochran case. Applicant wanted to subpoena the PMK, the person most knowledgeable about applicant's earning capacity. And I've seen this happen exactly once in my 30 years of workers' comp. And one also wanted to oppose the utilization review doctor. This wanting to subpoena and depose the PMK is, I'm not so sure applicant's attorneys want the information as they want to put the screws to the defense and force, for example, the employer rep to come all the way to California from wherever it is and to push for a settlement. Now, if we get there, we're going to talk about interrogatories not being part of California workers' compensation, although in the one case that I had on this issue, I was able to convince the judge that that would be far more reasonable, far more constitutionally acceptable, given the fact that the Constitution, California Constitution, requires that we do pretty much everything as expeditiously and fairly as possible. It'd certainly be more expeditious to do interrogatories than to fly out the defense and do the questions there. Of course, now that we're getting used to depositions online, that would have to hopefully resolve that problem. The issue I had was 20 years ago. How can it possibly be 20 years ago? So anyway, that's the PMK. And the judge said, yep, you can go ahead and subpoena and depose the PMK, but not so much for utilization review. Obviously, earnings is important in terms of TD and earning capacity, totally relevant, but there's no justification for deposing a UR doctor. What are you going to do? First, actually, the legislature got applicants, attorneys, and judges out of the world of prescribing medical care. So therefore, you can't file a petition, you can't file a request to depose a doctor. Like I said, if you remember the battle days, back in the PTP presumption days, those of you who are old enough, I'm sorry about that. You probably have some gray hair like I do. Back then, the PTP was basically a god, lowercase g-o-d. Whatever he or she proposed and prescribed, the defense was going to have to capitulate because the doctor, or the judge rather, was going to say, I'm no doctor. I have to give in whatever the primary treating physician says. It had to be pretty much an outrageous recommendation for it to be not denied by the judge. So that led to lots of overtreating. So you'd see cases with 87, 88 more rehabilitation and chiropractics, et cetera, et cetera. It just got crazy. So thankfully, we've got the utilization review to cut down on that. What about Zelnik? Well, the defense screwed up here. They didn't timely deny within the 90 days the site claim using the good faith personnel action. There was a claim there, and as I say, it came out more than 90 days. Tick, tick, tick. So it's presumed compensable. Judge says, well, 5402, which says the 90-day cutoff, if you don't make that, it makes it presumed compensable. Well, that means that you can no longer assert the good faith personnel action defense. Does that make any sense? Does that make any sense at all? Well, if that was true, perhaps you expand that to any kind of defense. Would that mean that we lose on AOE, COE on any case that's denied greater than 90 days? Obviously, that's not true or correct. And that's what the WCAB said. Well, they narrowed it to the facts at hand. It doesn't prevent the 90-day cutoff, and expanding past that does not prevent the assertion of the good faith defense. He said, well, yeah, it's presumed compensable, sure, but you can still present evidence of the good faith personnel action, and you can still win on that. And it doesn't matter when the evidence was obtained, you might remember, as long as if it was not obtained within the 90 days, that there was a reasonable effort to collect the evidence prior to that. If your reasonable efforts make it impossible or highly difficult, then we can obtain the information that we're going to rely on after the 90 days and still present that as evidence. So it's really, in a lot of ways, this is nothing new. Now, this could still have gone very badly for the employer. And that's because we have a regulation and a labor code section that say exactly that. 5505 says evidence not pleaded by the answer. Well, it's going to be up to the judge as to whether that information is going to be permitted. And what does the regulation say? It says exactly the same thing. Evidence not pleaded by the answer. Well, that's going to be up to the judge to allow. We don't see judges pushing this issue terribly often. More very aggressive applicants attorneys, but the rule and law are there, so we definitely need to be careful of that. Temporary disability. We got a furniture mover in EQ. The job was subject to drug testing, and guess what? He got drug test. He was modified. Strike that, not quite yet in this study. His modified duty after he was injured was washing trucks and office work, and then he got drug tested. Guess what? He didn't get found positive. He just flat out no-showed, and as a result, the defendant terminated him for his failure to appear for the test. The employer was able to prove that he would have had, and could have had, and should have had all this modified duties, and that even the modified duties were subjected to testing. The applicant says, well, that's not good cause. These modified work was not safety specific. You didn't need specific rules of safety to do this washing of cars and trucks and doing paperwork. And so the question was he entitled to TD? And the answer, happily for a change, was absolutely not. The WCAB said it's not, quote unquote, irrational. There's a reason I have that in red and italicized and bold, to test the modified work of employees when the regular work has safety specific activities and they're expected to return to that situation. That there was good, quote unquote, good cause. So as a result, of course, TD was stopped right after they were terminated. By the way, I really love the name of this company, the Meathead Movers. I've never heard of them. Have you? Back to the irrational. There's actually, back a million years ago, when you go to law school, you'll find that there's certain tests as to whether a law should stand up. And if it's merely needing to be rational for the law to stand up, or in this case, hopefully the employer's rule to stand up, is that it makes some sense. It's a 51% makes sense, 49% doesn't make all that much sense, kind of thing. Very, very easily, as compared in constitutional law to strict scrutiny, which is exactly as it says. It's much more difficult to enforce that rule. You probably have to prove 70, 80, 90% of it makes sense and needs to be applied. Whoops. So proposing a string rating at MSC, how many times have you proposed a string rating? Often, I hope, because if you haven't resolved the case at MSC, we have to specify in the steps and issues, of course, as the steps and issues implies, the issues and the list of exhibits and the witnesses, and most importantly for this case's purpose, each party's proposed rating. You need to know what first off, whether the report accurately reflects the AMA guides, and then adjusted for FEC or modifier 0.4, occupation and age, and alternatives. Obviously indicate that the mistaken report is incorrect per year rating and analysis. And by the way, we find at the analysis department here that about 80% of the time reports overstate the amount of TD and therefore the amount of permanent disability. So you'll want to really outline that in the STIPs and issues. So the proposed rating has been required by 5502 forever, and yet many parties don't do it. And it's certainly in this case, and I'll show you the date in a second, certainly would have expedited things. So the date of injury was prior to 1997, meaning the 1997 PDRS was appropriate. Those of you who were doing workers' comp way back and then are groaning, because those of you who weren't doing workers' comp in 1997, let me tell you, it was horrible. If you think the 2005 and 2013 PDRS with the AMA guides are tough, the 1997 to do it required magic, really. The employee said the PDRS is rebutted anyway, give me 100%. So nobody has explained what the string rating is, what the PD rating. Applicant just says, well, I think it's 100. There's a problem. No one told the judge what the strict reading, but nevertheless, the judge says, I can figure this out. The PDRS is rebutted. Well, of course, they're going to say that, and it's 100%. But there's a logic problem. How can you say that A, the strict rating, has been rebutted by B if you don't know what A is? If the defense had said the strict rating is 97%, and applicant's counsel had said no, it's 100 for the reasons, it'd be one thing. But only workers' comp can you completely ignore logic and still win the day or try to win the day. The WCAB said no, vacated, back to trial level, and please do it right this time, folks. Again, when we're filling out the STIPs and issues, make sure you have your ratings written down. You have your alternative ratings. You have ratings based on a true or accurate application of the AMA guides. About 2% of the time, that will be a bad thing for you. What do I mean by that? About 2% of the medical legal reports that we analyze actually state the high or find that the medical legal states PD or WPI higher than what we believe is actually accurate. Fun factoid, as I said earlier, this case was 26 years ago, the date of injury was, and as of the time I started putting this together, there had been no PD ruling yet. So the wheels of justice move very slowly. They move particularly slowly if the parties don't follow the procedures. Ledezma. I can't get away with that, but I can pass this off to Greg Fletcher. Mr. Fletcher?
Yes, thanks. I grabbed this case when Don asked me if I wanted to participate because I remembered this case. It came out a little over a year ago, and I just remember reading about it in Work Comp Central and thinking it was pretty outrageous. This gave me an opportunity to actually read the case, and I strongly encourage you to do so. It's highly entertaining. It will make your blood boil a little bit, and I feel sorry for anybody who had to deal with these folks. This case, Ledezma, is the first of 8 cases that were consolidated, and they're set on a notice of intention to impose sanctions and costs. This is an en banc ruling, so it's the whole WCAB got together and basically read these guys the riot act. But what happened was this hearing rep and attorney team, and they've got to be related. Their names are, let's see, Susan Garrett, and the other is Lance Garrett. So what they did, and you got to get a sense of how bad this was because it was repeated, not just over multiple cases, but each case has a history in which these folks, filed an application, or in one case, I think they represented a lien claimant. The defendants pushed the thing to a hearing. They had a couple of things they did initially. They would either call in sick. They said they were ill or in the hospital multiple times, and no one showed. They would request continuances repeatedly. They'd usually get the first one, sometimes the second one. The third one would be denied. Then when it came time, the case is set for trial, and in some cases they've been ordered to appear to the trial. They did the thing that they really focus on in the case, which is On the day of trial, they file a petition for reconsideration, and nobody from their side shows up. The applicant doesn't show, and the attorney or hearing rep doesn't show. Now, the reason this is problematic is that what they're doing is misusing the procedure, recons versus removals. And so the court does go into that. We can go to the next slide. Again, they filed these things on the day of trial, and typically what they were appealing was the order setting the matter for trial. So that's clearly a removal, and they say so right in the case. Now, to back up a little bit, there is a difference between recons and removals. I think there's slides further on that deal with that. But the main thing to remember is that a removal will allow the proceedings to continue. When there's a petition for removal, the WCAB can continue. For example, the trial would go forward. I think it's discretionary, but it's not stayed. A recon automatically stays the WCAB level. The WCAB cannot issue any orders. You can't have any hearings until the WCAB steps in. So it becomes a trick or a technique to get this. It's funny. It's not a removal, it's a recon, but what you're doing is removing it from the WCAB district office level, those judges. And that's what they were doing here. You can't have a trial because I just filed a recon. And then the board would have to deal with this. But it went over and over. And in all of these cases, the matter was set was brought up on sanctions and costs and attorney fees. And so they consolidated them all. And they found that, of course, the process was abused. And they awarded sanctions of $2,500 per person per case for a total of $20,000 of sanctions. Plus, I believe, costs and attorney fees on top of that. So this is a pretty penny. But at any rate, so there is one issue to address before that, and that is that we've got a hearing rep and an attorney. And I've always had issues with hearing reps because we can't report them to the state bar. But this case makes very clear that at the WCAB level, the hearing rep is held to the same standard as an attorney. Unfortunately, they don't have bar discipline, but they have WCAB discipline. They can award sanctions and cost and attorney fees against either a hearing rep or an attorney. So they dismissed with that. Then they do get into recons versus removal, and that is that's a whole area. You could do a whole lecture on that. The key is a removal is non-final. A removal is an appeal of a non-final order. They call it an interlocutory order. Nice lawyer word. A final award or final order can be reconned. And the way to look at this is if something is substantively been decided or awarded, that's a final order. It's a recon. But if it's a procedural issue, a discovery issue, then that's probably going to be a removal. And in most cases, you'll be able to figure it out. And the key is do it right. Do the inquiry, make a decision. But if you're confused, you can do a hybrid. You can say, I'm filing for recon or removal in the alternative. And if you do that in good faith, you'll get away with it. They don't like it because if you file a hybrid, it's treated as a recon and it does stay the proceedings. So you want to be careful about that. But none of us are going to do anything close to what these folks did. So if we're doing it, it's probably in good faith. We probably have a genuine concern or a question about whether this is a recon or a removal. And some orders are hybrid orders. The example I looked up online was, what if you have a hearing and the threshold issue of employment is decided, but the board orders the record developed on injury AOE-COE, and you want to appeal both of those things? Well, you file a recon and removal, and you say, I'm reconning the threshold issue of employment because that's a final order, final decision, but the discovery issue is interlocutory, so I'm doing a removal on that. The board treats them both as a recon, but they'll understand what you're doing. And that's not wrong, that's not sanctionable. What happened here was really the pattern in practice, just repeated abuses. And so I really think the thrust of the case is not so much on this issue of recon removal. It's instructive, But nobody, we're not going to be abusing it. We're not going to be filing recons just to get out of a bad situation. Clearly, these folks were never prepared. Who knows what kind of cases they took on. And they were dragged to the board, and they tried every excuse they could think of up until the trial, and they're ordered to appear in some cases. And then they pull this rabbit out of a hat, which ultimately results in these cases and their sanctions. Now, we do have an appellate expert, Louis Laris, in the firm. I strongly urge you to contact him if you have questions. If he can handle some of these appeals, but he's done this way more than we have, and he's thought these things through. And so, if you have a question, whether it's a recon or removal, he would be a good resource, a good person to ask. So I think that's pretty much it on that case. But again, the good news is the board will punish bad actors. The bad news is, look what it took to get there in this case. I mean, if you read these facts, this is over the top egregious. You've never seen anything like it. And yet it took this long to get them down to the board, get these things consolidated, and get sanctions. So good result, but kind of an unusual one in California workers' comp.
We finally got the result we were looking for. We got that tiny hole in the dike, and hopefully that means we can start pushing other cases, maybe not quite as extreme. They're usually pretty extreme when we want to spend the money and effort to go down that path. But we find something even not quite that extreme that will get a better reception by the WCJ and the WCAB. Again, in the past, we got virtually no reception, and certainly not a good one.
One thing I would suggest very quickly, if you're dealing with a bad actor, somebody who is going to repeat the kinds of things you're objecting to, keep a file on that person. I think your first petition for sanctions is going to probably go by the wayside and be worked out in some way or just denied. But when you come to the board and say, this is the sixth time this person has done this, we're not going to have, this behavior won't stop without a remedy. The board needs to step in. I think your chances of getting that sanction on some further time. Now, they may argue it's irrelevant, but I think a pattern and practice is worth bringing up to the board.
Thanks, Greg. I just want to put one more thing out about Lewis, who's a partner down in the Fresno office. He has filed probably hundreds of recons, all of them legit, by the way, and has filed appeals and worked at appeared in every single double court of appeals in California, and has also argued before the California Supreme Court. So I don't know anybody in California who knows the recon and writ procedures and arguments better than him. And I go to him regularly. And even if you've got a recon or a writ and you don't want to hire us, by all means, scratch his brain, see if he can provide any insights. If you're thinking that you might be going down that path, but haven't finished the trial or just want to go to trial in a way that will set you up better for a recon and or a writ, please also talk to him, because he may be able to give you some strategies as to what evidence to enter in, whatever evidence not to enter in, and how to proceed with your arguments. So yeah, definitely a wonderful source of information. 5710 fees, one of our least favorite things to do, and we always end up paying, it seems, on every case. What do you know? Or what do you need to know? Obviously, they have inflated. In the time that I've been doing this, they probably up a magnitude of 5 or 6 or 7. They're clearly inflated, and oftentimes applicants' attorney are relying on what the WCAB as purely clerical, and nobody likes that. Defense attorneys aren't allowed to bill for perfectly or purely clerical, and we're not going to pay applicants' counsel for that either. The scheduling at the deposition, the notifying the applicant about the depo, absolutely not payable, and the Cohen's case says that. Now, this case, or this it refers to the WCIB's rules with regards to appeal fees. That is, if the applicant's counsel files a writ or a recon, and they say these are the things that they're going to consider. And the reason I wanted to take a look at these considerations is, I believe we can convince the WCAB or the judge to, if we're fighting attorney's fees, and it's not necessarily something we can often get into, but if we are in a rare instance fighting applicants' attorney's fees, we might want to also use these appeal fee rules as an outline for our points and authorities. First, they consider applicant attorney's time, their effort, their care, their experience, their skill, complexity of issues raised, and the length of a reply, the number of cases cited. So we're talking about issues that are novel, or there's opposing published opinions that the attorneys then have to overcome, or it's complex, intertwined. Where have I heard intertwined from Code Section 4664, or numerous and are above average complexity. So what's an applicant's attorney's really worth? Let's see here. Effort and care. Question, did applicant's counsel pay attention, properly object to questions, read a newspaper, or fall asleep? I kid you not. On my first ferry deposition when I was about 6 years old, got about halfway through, and I heard it, what's left of me? Then, of course, that was applicant's counsel. And I had fresh out of law school, and I'd taken ethics, and I knew that I was not allowed to contact a represented plaintiff or applicant if their attorney wasn't there. So was he there or wasn't he there? I don't know. So I did the only thing I could think of, and that was, okay, where did you go? Never woke him up. Seemed to work out just fine. As I say, I've actually seen this garbage. Skill and results. You take a look at the transcript, you should have a great deal of guidance on that score. It's complex. Come on. It's an applicant deposition. How complex can I hurt my back and now I can't do a darn thing be? It is not the simple plan what we see in this picture. All right, 99-cent store, which from what I understand in the news is now charging about $1.25 or more. So it was a great store name for a while. Applicant's counsel or hearing rep wanted more fees, and basically in substance here is, yeah, probably ain't gonna get as much as an applicant's attorney, Mr. or Mrs. hearing rep, unless you show quote sufficient substantiation. Judges are really going to go look askance at that, and I strongly see if there is a push or comes to shove, we definitely want to look how they handled the deposition. Again, did they object? I had a deposition many years ago with a doctor and a hearing rep, and the hearing rep clearly did not know what he was doing. So every question, I mean, literally every question, including the doctor's name, he had 6 or 7 written objections, and he gave every single objection. I finally said, okay, I'll stipulate that you're objecting with those 6 objections to every single question. Okay. Clearly, those aren't sufficient. That information would not be substantial or sufficient substantiation. Now, since HR fees could only be awarded under the umbrella of a law firm, the value can be judged only by attorney guidelines. What are the attorney guidelines? Well, some WCAB district offices have outlines, non-binding outlines that have been put together by a judge, the PJ usually, applicant's counsel, and defense counsel to come up with rates that they find would be reasonable for an attorney for 1 to 3 years, 3 to 5 years, 5 to 10 years, et cetera, et cetera. If applicant's counsel is relying on it, I mean, you may rely on it as that defense tool, but if applicant's counsel is relying on it and you don't want to, the answer to that is, judge, do not take a look at that. It is not anything but paper. It is not evidence. And you can't even consider it. And there's case law on that point exactly. It ain't evidence. It ain't nothing. It's just where you can burn it up. Continue with our 99-cent store. It's determining reasonable attorney fees. They're going to, again, consider the responsibility, the care exercise, the time involved. And what's interesting in these obtained results, we've got one law firm that on the other side that we've been dealing with lately, who has a voluminous number of files, and they settle virtually everyone at the deposition. There's not a lot of care. That's not a lot of responsibility. That's certainly not a lot of time. And if the results are that they settle it for $1,000 and get their 5710 fee of $500, obviously that's not the kind of results that the WCAB is thinking of. If you happen to find a law firm that fits that characterization, I can't name this law firm. Definitely keep an eye on them for potential points and authorities and sanctions. Okay, Thorson, the reasonable travel time and the 5710 fees, the last consideration we're going to deal with. Sometimes we've got law firms that are applicants' attorneys are saying, well, we're here in LA County, but we want to become also have a appearance or have a presence in San Francisco or Sacramento. So we're going to send our attorneys up to San Francisco or the Northern Country and attend the deposition because, heck, the defense has to pay for all reasonable costs, and certainly having an attorney at the deposition is reasonable. And the answer is not yes, it's not no, it's a heck no. You can have the deposition applicant's counsel at the county of the injury, at the county of applicant's residence, at the county of the employer's principal place of business, or the county of the applicant attorney's principal place of business. I've had a couple situations in which, many situations actually, in which the applicant moved oftentimes out of state, thankfully not out of country so far. And applicant's counsel, well, it depends on what they want, but there's lots of options here. I would always, despite in that situation, despite what applicant's counsel elects, would argue that we should, and would have the deposition at the injury, at place of injury, principal place of business, or principal place of business of the applicant's counsel or the defense. There's no real good reason for sending 2 or 3 attorneys up to Timbuktu handle the deposition that became handled by just having the applicant fly down or just doing it via the overlying. All right, that's exactly what I was trying to remember the name of, Zoom. So hello Zoom, goodbye travel. And this is exactly what I was talking about. Are there things that are questionable? Deposition review time. At every deposition, I ask the applicant how long have they met with their attorney. How long did you talk with the attorney in preparation for the deposition? Because it's funny, if you ask applicant's counsel, it's always at least an hour, and very often the applicant doesn't remember that long. Applicant's attorneys are also billing for document production, depot coordination, etc. And the answer again is absolutely not. Often, when the applicant comes in to review the deposition transcript at the applicant's attorney's offices, applicant attorney will bill for that, but there has to be an applicant attorney involved in the process. So if they're doing it on their own, or if they're doing it with a secretary, absolutely not. That happens the vast majority of the time. We noticed doing notice to produce documents, various documents for every deposition, and most often they're not produced. So if applicant's counsel wants to produce them at some later time, but bill for it now, absolutely not. So it's nice to know we've got case law on all of this to put a kibosh on some of the, or pretty much all of the inflation to 5710 fees. By the way, I did an article or a blog article that's on our website called a bit of years ago called "What's an Applicant's Attorney Worth?" It ticked off feeling like the applicant attorney friends, but it includes some citations that may be useful if you want to go down that path. Ravascati, we're doing pretty well on time. The judge said, well, they're 100% because the doctor said dental and not combined with facial disabilities. The WCAB said, no, because the QME didn't do it the right way. The doctor just addressed each body part and its impact. It's not the impact of just each body part on the body. It's each injury on the body. You've got to take at the specific ADL by each impairment. And you have to determine whether there's any overlap of the ADLs, or is there an ADL overlap that increases or decreases the injury impact, such as our little friend, the kite case. So what to do if the QME actually corrects the report? We need to depose the doctor. I'm a big fan of deposing doctors on a regular basis. Used to be in the bad old days that you couldn't do very much. We relied on 1997 PDRS, and the asked doctor, how did you choose to give it a no very heavy lifting, repetitive bending, and stooping? The doctor would say, based on my clinical exam and my years of experience, I thought this was a no very heavy lifting, repetitive bending, and stooping. Wonderful. What are you going to do with that unless you got film? Now it's more fun. They said back in the day, you didn't challenge the doctor on the medicine. You chose them only on you challenge them only on the law. That's not true anymore. We've got the law. We've got a big book of the law. It's a 600 plus page book called the AMA Guides. I personally use our AMA Guides rating department. Although I founded it, I use them because they're much faster and much more proficient in doing an analysis, so I can rely on it and attacking the doctor in deposition. Also, we definitely spare no expense doing medical research. You want to prepare for a doctor's deposition. You want to find out what the latest and greatest is about that particular medical condition. We use a thing called, I remember, it's called Google. And Google is very, very helpful. I found many, many studies that I could cite in depositions. Say, doctor, have you considered this? Have you considered that? And invariably, the so-called expert has never considered it because he or she has never seen these studies. Speaking of doctors, when you take a doctor's deposition, always subpoena the doctor's file. I have never taken a doctor's deposition without doing so. Why? Because you'll never know what you'll find. I have literally never not found something of value when subpoenaing the doctor's file. I literally found one doctor who had records in his file that he didn't want there because it proved, one, he was treating our client, or the applicant, which is entirely appropriate, that he was billing my client, which is entirely appropriate, and then he was billing the federal government for the same services, which is, legally speaking, considered a naughty. I actually advised the doctor of this when the court reporter was typing it down on the record, and he looked at me and said, and I quote, "That wasn't supposed to be in there," end quote. Yes, doctor, I stipulate to that. I've also found situations such as, we were talking about the Epworth study, if you remember that, for the paper and pencil study for purposes of determining the sleepiness scale. And I found one doctor who was changing the scores. When I asked him who would change the scores, he said, well, the applicant had, because after taking the test, he had explained the questions to her, and then she changed it based on that. Well, by the way, if you read the instructions for Epworth testing written by the creators of the Epworth test, they will say that makes the test null and void. So that and a whole lot of other wonderful stuff you can get via subpoena. The WCAB has discretion to grant or deny commutation. What's that about? That's, say you have a stipend award and a continuing award at the present, or per total or per partial, or even partial PD going up to, let's say, 60%. And after he starts getting PD and realizes, wait a minute, I need a chunk of money. And who amongst us doesn't? Well, that was the case in this situation. The applicant stepped to an FNA. Oh, don't you love FNA? FNA. It sounds obscene. FNA, somebody cuts you off on the freeway. FNA. Stepped to a 76%. And Skiff paid for a long while at $160 a week. And he said, I want a complete commutation. I want all my money forthwith. And by the way, if he or she does receive that, we get a rebate of interest of 3%, a rebate, which is math I can't do. No, we can do it. And actually, I believe we have a calculator on our website that helps you do that. And the answer was, nope, you can't get that commutation this time. Sometimes applicants can get it, sometimes they can't. He had testified to an income of about 2,500, and then he was already behind every month. He was borrowing money from his daughter, provided no information or no proof of that, but nevertheless testified to that. And the judge said a 5,500, 5,100 day says a commutation is allowed if, and this is very easy math that even a defense attorney can do, it's necessary and it's in the best interest of the applicant. Notice the employer is not listed. It's no longer, a commutation is never considered positive. It's never considered whether we're going to do a commutation, thumbs up or thumbs down in the interest of the employer. It's always the applicant. And it must be, the decision must be based upon the desire or the need to avoid inequity, undue expense or hardship to the applicant. So it is up to the applicant to prove that. So the WCAB is very disinclined to agree to or to allow a commutation. They say that, you need to save the applicant oftentimes from him or herself. A commutation could cause an undue hardship. In other words, you get the lump sum, you spend it all, and now you have no income for many, many, many weeks or for the entire life of that of the PD that you should have been receiving it. You lose your income stream. Now, how do you defend these things? Well, first off, you have to decide whether you want to, because remember, you do save 3% interest, and it may cost more to defend it than it's worth. I've only had a few of these, but I won them all, I'm happy to report. First off, you simply point out how much debt this applicant has, which was done in this particular case. You take a look at their credit cards. I did that in one of my recent cases and said he's got 6 credit cards. They're maxed out. Now, either the credit cards are going to grant him a pass or put him into bankruptcy, but they can't take money from a turnip or get money out of a turnip or a rock. So giving them a lump sum would mean that they would go straight to the credit card companies. And WCAB, you don't want that. Obviously, we take a look at the credit score, and if it's low, and I think most applicants in this situation have pretty low, if not outrageously low credit scores, they're not going to be in this position to really purchase anything without that income stream. So they're very easy to defend in those cases in which we would want to defend them. Ball trip, how are we doing? 10 more minutes. Ball trip, we have, this is crazy one. AME, I hate AMEs. And I've gotten on my soapbox many, many times as to why I virtually never, like 98% of the time, don't go to an AME. I need 15 minutes to discuss that, several reasons for that. But if you're at all interested, please look on our blog on the website called Why AMEs Agreed Medical Examiners Make Me Disagreeable. So the AME said, we got grip loss, you got range of motion, and you got pain. So I'm going to add them up. Now, the AMA guide said you do not accept in rare occasions, but nonetheless, that's what the AME did. It came up with 97% disability. 97% disability. The reason, okay, they say, the judge said, well, but the guides say you may consider range of motion in rare cases where the strength of impairment isn't fully compensated by other methodologies. Sort of a Guzman thought. So what does rare mean? According to the Oxford Dictionary, not very often, which would lead to the doctor's deposition of, hey, doc, how many times have you misapplied the AMA guide? This is a case that definitely would have should have been deposed. There should have been a deposition, because I virtually guarantee we would have not paid the 97%. Of course, the doctor said, hey, a Guzman type of situation, range of motion and pain did not adequately reflect the inability to provide maximum force. Wait a minute. If you can't provide maximal force, is it possible that range of motion caused that? I mean, absolutely. And why is it sometimes you don't do things? Because of pain. So aren't we double counting here? Clearly we are. And clearly this is something we need to debate with the doctor in deposition. Okay, the doctor said that there's other activities like opening and closing bottles, fine manipulation, dressing and undressing, etc., that were caused by his brain motion, pain, etc. So where did the employer go wrong? First, this was begging for some Rosa. Basically, the doctor said he can't use his hand. In fact, the doctor rated higher than the loss of a hand. There are too many restrictions to hide, so definitely some Rosa. Definitely needed to review the ADL. There's so much overlap. There's almost complete overlap. So a Guzman type situation, totally uncalled for. And as I've suggested several times here, Dr. Deposition was absolutely called for. Well, let's take a look at this. Okay, this guy said he had a hand injury with some loss of range of motion and grip loss. Let's pretend instead of that, it was much worse. He lost the entire thumb. Sorry about the gross picture. That's, I mean, guys, 40% hand or 36% upper extremity or 22% WPI. If you get rid of both thumbs, that's 38% WPI. Which would you rather have? Some grip loss and pain and range of motion in one hand or losing both thumbs? I think that's an easy answer. It seems clear to me that loss of both thumbs would dramatically impact your ADLs far more than would a little problem with one hand. So total hand, I misspoke that, this is a typo, is 54%. And what did we say the doctor actually gave? It was 94 or 96%. Would you rather lose a hand or would you have just have some problems with the hand? I think it's real easy. If you lost in this, it's 79% was potentially, although obviously there would be a Guzman/last kite situation here, but a strict application of the guides, both hands would equate to 79%. Once again, the doctor came up with, what the heck was it, 97%. So doctor, if they lost both hands, this is how much it would be worth. But you gave up with something, came up with more permanent disability. How in the world did you do that? I would love to take this deposition again. The defense failed to, and that was rather sad. Definitely time for points and authority. 1870, the Ortega bill that went into effect on January, because employees weren't getting enough notifications. Now there must be a poster with each employer that they're entitled to receive medical care, to elect PTP, to receive indemnity, and report injuries to AOE, COE. Think about it. And also the right to consult an attorney, and that their award of the applicant's attorney was going to come out of there. And their award, the applicants are going to, it's from which the applicant's attorney's award is going to come out. So therefore, they don't have to front the money. So I think goodness for 1870, because how in the world could an injured or fraudulent applicant learn about applicants' attorneys? Crying out loud, it sounds like there's commercials all over there saying injured, or billboards saying injured. Oh, wait a minute, there are. Hardesty. I'm going to skip this, and I'm going to, because we're definitely on the way to run out of time. Just this interrogatories. I said interrogatories are not allowed in California workers' compensation unless they're really necessary. That is the same reason that we don't adopt the California Code of Civil Procedure, because, well, they say we're not going to do a wholesale because it's inconsistent with the California Constitution. Now, what does that require? The Constitution requires that workers' comp be, quote, substantial justice in all cases, expeditious in all cases, and inexpensive in all cases. If we can make the strong argument that the interrogatories provide more justice, are faster and less expensive than other methods of discovery, we've been able to get the interrogatories in under the I have no idea what it's going to be under. Anyway. All right, so there we go. All right. Oh, here we go. Remember in 4663 D, and this is the last one I will do, the applicant is required to provide all permanent disability or history of physical impairments. In this particular case, they were asked for 10 years worth of it, and they were found, no, that's too burdensome. You can't ask that. What? 4663 has no limitations, and yet the WCAB seems to think that more than 10 years should be is too much of a burden. So apparently it's going to be the applicant who decides what the permanent disability or impairment is that he's going to report to the defense. But is that the applicant's job? Does he or she know what it is? The applicant's counsel, the WCJ, not clear. What about do they even know what disability is, especially the applicant, and how it's rated using the AMA guides? We know the answer, but it seems to imply that the employee only needs to reveal rateable injuries, A, we see, OE. That's a bunch of malarkey. And if you face this situation, please give me a call, because this case is bad law, and we do need to get rid of it, because otherwise, basically, 4663 is dead. Applicant pretty much need to provide us nothing in terms of past impairment, past PD, past WPI. All right, 2 minutes left, and Tammy asked for 1 minute, so I'm going to pass it off on to her. After I say, did you hear about the cannibal who got expelled from school? He was caught buttering up his teacher. I apologize for that. Tammy?
I'm so impressed that you ended with 2 minutes to spare, Don. This has got to be
Tammy,
the first time.
real quick,
Yes.
somebody has asked how to get the link to the blog, and I'm responding that they should email you, and you
Sure.
can provide them all the information. So I'm just letting you know. Okay,
Absolutely.
very good. Thanks.
Yes. Thank you, Greg. Thank you for answering all the questions in the background, Greg. He took care of all your questions today. He did a phenomenal job. Thank you so much, Don. Take care, everybody.
Have a great summer, y'all.
Thank you.
Thank you.